Good morning to all of you. This is also for the final year students, professional ethics. What is misconduct? Section 35. Every time we cannot define what is misconduct. Now, today we are going to discuss a point. Suppressing of material facts, whether it will lead to misconduct or not. I hope all of you will agree and say, yes, suppressing the material facts, particularly regarding conviction. You may be knowing Section 24A of the Advocates Act says about the disqualification of the advocate. Suppose if the advocate is convicted in a case of moral turpitude. Again, what is moral turpitude? We have discussed a lot of cases. If he is convicted in a case of moral turpitude, and if he is convicted in that SC/ST cases like that, so he is disqualified. But here the point is, after conviction, you are going to keep quiet, is it not? You will go for appeal. So in the appeal, it may come in your favor, right? At that time also, please remember, whenever you fill up the application for the enrollment or something like that, you have to state that the case was booked against you and it has been convicted. Ultimately, later you filed appeal and it went away or it was dismissed in the appeal. Like that you have to inform. But don't be under the wrong impression that since it has gone away in appeal, you need not file. This is the problem here. So please remember, you have to inform the material facts to the court or to the bar association. So please remember, do not suppress the material facts. If you suppress, definitely it will be taken as a misconduct and the matter will be referred to the Bar Council under Section 35 of the Advocates Act. So while disposing the case of Shardul Singh versus Pritam Singh, Shardul Singh, S-C-R-D-U-L versus Pritam Singh, 1999, right? Here, actually, Pritam Singh was an advocate. He suppressed the fact of his conviction in a criminal case. He was convicted in a criminal case. Of course, later he became an advocate. He got enrollment. So he was under the impression that he need not inform the bar council regarding the case was dismissed to the appeal stage. So why, please here the important point you have to remember is why they check up your credentials, why they write your antecedents, why they require your antecedents. So not that the cases, it actually helps the bar council in assessing your character, not conduct. Please remember, character. What type of person you are. So whether you are frequently indulging in say criminal cases or whether you have been unnecessarily involved in a criminal case like that, if you give the details, then only they will come to know. If you don't give the details, how they come to know? Is it not? So please remember, here he said he has suppressed the fact about his conviction in a previous case. Bar Council, they will take it very seriously and they have suspended him for 3 years, right? So then he has gone for review. I think it is for Section 44, I believe, or 47. I cannot remember correctly. So the Bar Council of India has got power to review its own decision. Now, once again, so he approached the Bar Council and Bar Council of India in the review position, since he has explained them properly that the case has been ended in acquittal like that, dismissed in the appeal stage, they considered, once again, they have restored. So this 3 years, without the 3 years suspension, he was once again inducted into the Bar Council. He is practicing, right? But the matter was taken by the Supreme Court. The matter has come to the notice of the Supreme Court. Supreme Court, please remember, set aside the review of the Bar Council of India. Arey, what is this? When the person has suppressed the facts of his conviction, he wanted to take it a lenient view and he wanted to release him. You have suspended from 3 years, it's correct. But the Bar Council of India, in its review, how can you go back your own order? So that too, when it is a conviction, when the person has been convicted. So such type of persons do not deserve to continue in the noble profession like legal profession. Supreme Court has taken very serious view, right? Because it is a very serious conduct. Suppose had he written that he was convicted and later he was the appeal was allowed, yes, it would have been better. But how can he suppress the fact? So that means Tomorrow, if something, he can suppress the facts of the complaint. So then he can say, if the case is convicted, he can inform the client that if the case is ended in acquittal. He can give a fake decree order. He can give a fake order like that. So such people should not be entertained. So once again, Supreme Court of India set aside the review by BCA and suspended him for, of course, only 2 years are left over. So they have taken it as very seriously. So therefore, remember, do not suppress the material facts. So whatever is there, please write in writing. So here what I advise is, మీకు ఏదన్నా కేసు ఉంటే, కేసు జరిగింది, కేసు శిక్ష పడింది, ఆ కేసు అప్పీల్లో కొట్టివేయబడింది అంటే ఎవరు మాట్లాడరు. అంతేగాని సహజంగా ఏమనుకుంటామంటే, కొట్టేశారు కదా అప్పీల్లో, ఇంకా కేసే లేదుగా, వై షుడ్ ఐ ఇన్ఫార్మ్ అనేటువంటి భావన ఉంటారు. అది కరెక్ట్ కాదు. ఇది చెప్పడానికే ఈ కేసులో చెప్పాను. ప్లీజ్ రిమెంబర్ దిస్. Shardul Singh versus Pritam Singh, 1999. So suppressing the material fact, it amounts to professional misconduct. Thank you very much.